Hello and welcome to another edition of Hard Copy, coming to you from our studios in Abuja. I'm Maokwe Ogun Yusuf. My guest tonight is a woman of many parts. She is currently the Special Assistant to the President on Justice Reforms and International Relations. Juliet Ibekaku-Nwagwu has served as the National Project Coordinator for the United Nations Office on Drugs and Crime, that's the UNODC, and the legal advisor for Intergovernmental Action Group against money laundering and financing of terrorism in West Africa. She's also served as the acting director of the Nigerian Financial Intelligence Unit in the EFCC. Juliet Ibekaku-Nwagwu, welcome to Hard Copy.
Thank you very much. It's nice to be here.
Well, a very impressive resume you parade.
Thank you.
I'm wondering, though, when you were invited to come and serve with the president and advise him on justice reforms, considering the fact that the president has said that the judiciary is his headache, did you think that you had the cure to his headache?
Well, thank you very much. As you're aware, this is something that has been ongoing. Let me start by saying my work is with the Office of the Attorney General of the Federation and Minister of Justice, which means that we must have a strategy dealing with some of the concerns that we have with the judiciary. But the concern is not just about the judiciary. It's also about looking at the entire justice sector. And that means looking at from the policing side of things, looking at how our investigations is conducted, looking at the prisons, what is happening with the prisons, what we can do to change that. And of course, the judicial process. And a lot of work, as you are aware, is going on with judicial reform. That is not to say that the executive would intervene in what's happening with the judiciary. What's happening here is that the executive, through the Office of the Attorney General of the Federation, is working closely with the Chief Justice of Nigeria to look at those areas where, first of all, if that is something that the president can intervene in, the president will come out, especially in terms of funding. And the president has succeeded in increasing the funding of the judiciary. As at today, as at 2019, to 110 billion, making it the first time from 60 billion to 110 billion. That's a significant jump. He has also succeeded in, having discussions with the Chief Justice of Nigeria about how to tackle corruption within the judiciary. And that's because...
Let me quickly take you on this. What are the priority areas? You've talked about, an increase in allocation to what the judiciary gets, even though, yes, it's supposed to be first-line charge. They should make their budget, ideally, and then demand it from first-line charge. But it would seem that somehow it is the executive which is still saying, you know what, here you can have an increment in terms of what you get. Is that what is happening?
No, that's not what's happening. Most often than not, all the budget priorities are set out. The executive have their own budget priority.
Yeah.
The judiciary has its own budget priority, as well as the National Assembly, the legislature. But then you have to put that together into a basket and look at what revenue is available to the government over a period of time. And that's where the Minister of Finance comes in to say, okay, we have available 100 billion, for example. We can only have this for executive, have this for the legislature, have this for the judiciary. And in making those decisions, the judiciary will be part of that decision. The executive will be part of that decision. The National Assembly will be part of that decision. But then, you have to look at overall interest of the country at the end of the day. So when I talk about those concerns and the priorities, it's really about how do we see the judicial process as a very significant part of the reform agenda of the president. And that is not something that has been considered in the past. And that's why we would say he has prioritized judicial reform as a very important component of governance reform for the country.
What aspect of judicial reforms? When the Administration of Criminal Justice Act was passed, there was huge optimism in terms of how the courts were supposed to run, what should happen to awaiting trial inmates and things of the sort. But it would seem that all that has been paid to it is lip service.
I wouldn't agree with that position. Well, let me tell you why. Once that bill was passed, the AJA bill, we call it, the Attorney General of the Federation, in collaboration with the Chief Judge of FCT, because what was passed was meant for the federal level, and therefore you have to work with the states to make sure that the states can implement their own AJA. They have to pass it at their state assembly. Now, at the federal level, a committee was set up in line with the ACJA 2015. The essence of that committee was to monitor the implementation. And so we have the Chief Judge of the FCT, who is the chairman of that committee. We have the Attorney General's office as the secretariat for that committee. And we are impressed with the progress we've made. And why do I say so? When you look at the timeline for judicial decisions in criminal matters since 2015 to date, you will see that most of those cases are able to finish within 2 years or 3 years. But look at that with what happened from 2007 to 2015. Most of the cases that we had, especially with corruption cases, some of them were in court in 2015, 2016, starting from 2007. But with the ACJA, the judges are insisting that you must finish your cases within a certain timeline. You will not be allowed to have adjournments more than 5 times, unlike what used to happen. And we've stuck with that. Within the same ACJA provision, we're also looking at different regulatory frameworks to work with the police. In fact, we had to get all the case files from the police to make sure that the Director of Public Prosecution of the Federation can begin to look at those things that cause delay, especially at the lower court, the area court, the magistrate court. And so we're implementing most of the requirements that ACJA has set out. What we are now looking at is also the prisons correction services. As you know, Nigeria just passed a correction services law, changing the way the Prisons Act was before, creating what we call non-custodial sentences provision in the new law. Now, with the Prisons Act, or if you like, sorry, the Correction Services Act, we're looking at rehabilitation as opposed to punishing somebody in the
Are you saying then, from what you have said, that at the federal level you have no problem with the ACJA? What is happening where you're having a huge challenges with the states?
Now, with the states, you know, the federal is not responsible for such matters at the state. But what the Attorney General has done is to work closely with the Attorney Generals of all the states and has created what we call if we can call it Association of Attorney Generals across the states, and they meet at least twice a year. And today we have more than 20 states that have passed their own state law in line with the ACJA 2015.
Are you saying then, I mean, because the taste of the pudding is in the eating. If we still go to our prison cells and we still have a huge population of awaiting trial inmates, if we go to any police station today and behind the counters in the cells, we still have people who were just arrested on one offense or another. We still have inmates who are being paraded even before they have been tried. They're supposed to be suspects, but they're already being paraded as people who are said to have committed a crime. Can we really say that ACJA has been implemented?
Now, you must understand that the point at which the Office of Attorney General comes in is different from where the police is expected to start their work. And in terms of that, what we expect is that the police will also implement their own positions, or if you like, the requirements of the Act. Let me say that with the prisons, what we have done is that the Attorney General, also under the chair of the Chief Judge of FCT, also set up a prisons reform committee. So we have a prisons decongestion committee that is working with the states. So you realize that it's a problem? We of course we realize there's a problem.
And it's not over yet.
And it cannot be. And it cannot be because the criminal justice system is so huge. And when you are dealing with criminal issues on a daily basis, you realize that it happens every day. And you just have to be moving. You have to make sure, the most important thing is to make sure that there are proactive measures to deal with them.
Let me take you up on this one, which is the rule of law. If you speak to quite a number of lawyers now, the chances that you'll get 80%, say I speak to 100 lawyers, the chances that I'm going to get 80 lawyers saying that they feel that the rule of law has been under threat under this administration are quite high. You know, they'll cite quite a number of examples. They'll tell you about the judges whose homes were raided, which they said was not the right thing to do. They'll tell you about non-compliance with court orders, and they will give you quite a number of former NSA. They will tell you about the Shiite leader in Kaduna State, and then bring in the latest one now, Sowore's case, where he's said to have complied with the bail conditions, still the DSS will not release him, and nobody is saying anything about it. How do you defend that the rule of law is not under threat under this administration?
Well, you know, when we talk about rule of law, it encompasses everything, starting, like I always say, starting from the process of arrest. When a crime is committed, from the arrest to the policing investigations, before it gets to the court, before the court will take a decision, and that decision has to be enforced. And so when you look at the preponderance of cases that we have had in this country, at least from May 2015 when the president came into office to where we are today, in terms of your assessment, would you say that 2 or 3 cases would then determine whether this government is actually complying with the rule of law? And I would differ from that.
In other words, that you don't have any defense for those cases?
Let me come to that. I'm just saying that in preponderance. Now, when we talk about compliance with the positions of the court, the government has tried in every way possible to ensure compliance with the decisions of the judiciary. And that means that in almost every cases, you have seen compliance. When these cases came up, and I'm not talking about Zaki, Dasuki, Sowore's case, I will not comment on it because it's still an ongoing case and I want to understand what's happening there before I comment. DSS came out the other day to say, oh, we are waiting for somebody to come and take Sowore from...
Which some people say is strange.
But let us hold on. I think let's give them time. Let's hold on for the DSS and determine what they want to do in, in Sowore's case, because that decision was given, I think, early this week. And DSS said that...
No, last week. It was given last week.
Okay, now, there are 2 things here. The bail condition would have said, so and so person should come and take him on the bail. But I don't think that I think it's a bit too early to say, oh, DSS is not complying. Let's just give them this week and see what's happening. In the case of that,
and if by the end of this week they do not comply, what do we then say?
I think it's a matter that is before the court, and I think that the Sowore and his lawyer can go back to court and say that we have a problem here, and I'm not being released. Because the court has taken judicial notice of the fact that he has met his bail conditions. And the court has a duty to make sure that DSS enforces that decision. That is a matter, and I think I want to leave it at that. In the case of Dasuki...
Isn't that a matter that will concern you, though?
That's exactly what I'm saying. The court has a duty to make sure that their decision is followed. And so what we expect is that...
What about the executive? The executive arm of government has a duty to ensure that court orders are obeyed.
When you say executive, you're talking about executive. Mind you that this matter came to court.
The presidency, which you advise, is the head of the executive.
He was brought to court on the basis of a crime that was committed.
Indeed.
Yes. And the court has said, we are ready, you should come. These are the bail conditions. It was not met initially. It came back
because they were stringent. That's another kettle of fish.
That's another thing. That's a judicial discretion.
Which I do not want to go into.
That's a judicial discretion. Nobody would influence the judge to say, you know, the bail condition or the sentencing should be X, Y, Z.
Yeah, but there are huge questions as to why this is the matter, especially why this is the case, when it involves cases that government is prosecuted, especially against known persons. This is not me just saying this. This is the observance of critics.
But this is what a critic that should go to the judiciary. Because the judiciary, you can't say to a judge, okay, you should charge 100 million, or you should, there's intimidation on the part of the executive. That's why the judiciary is taking the cue, to do that. I would disagree with that, because nobody will tell a judge under a particular circumstance what to determine for bail condition. That is a judicial discretion, and this is really where sometimes I feel that we don't understand that there's a very, very big gap between the judiciary and the decision of the executive. Remember that there are so many cases that come to court on a daily basis. We only get to hear about those cases when that person is somebody that is well known in the society. What about cases that you and I don't know about? And yet those the same bail conditions have been applied to those cases. And so we need to make sure that we really understand the dynamics that are playing out between the judiciary and the executive in some of these cases. And it's completely not within the powers of the executive to say to the judge, you need to apply the fine of 100 million in this case, and then in another case you should do 50 million.
Perhaps not as blatantly as that, but perhaps there is some, I don't know. Do you think that the judges themselves feel that they have the freedom, the independence
they have
to
the
carry
freedom.
out their discretion with true
there's
independence?
no judge in this country that would say, by the way, who will make that call to this judge?
I don't know. The question is to you, Mom. But we take a break at this moment. When we come back, our guest threw her hat into the ring, attempting to unseat Nigeria's then Deputy Senate President. Was her experience in the world of politics same with that of the courts? We'll find out in a moment. Please stay with us.